Hey, so let's talk about being a Social Security disability or SSI claimant, and you have a burden of producing evidence for the SSA to make a determination under its rules as to whether you are disabled and otherwise meet the criteria you have to meet to receive benefits. Okay, so as you probably know, on initial consideration and reconsideration, the SSA will generally assist you in getting that by ordering all the records of the providers that you gave them full detail for contacting and timeframes when you saw them. It's really helpful because then you don't have to get them. And the SSA actually pays whatever the arranged price is between the SSA and the providers under the law. So it's nice that you don't have to do that. And they pay for it. Now, there comes a point where sometimes you do have to get involved and be proactive on your own case. And you'll know it if you're paying attention to your case and you realize that the SSA didn't get something, or it may have tried and the doctor isn't forthcoming, whatever the case may be. And now you have a deadline and you need to get that stuff in. So you request your records on a HIPAA form of some kind, and there are various kinds to get your records. There are times when some providers, I don't know if it's out of ignorance or it's out of, I don't know, they don't think anyone's going to hold them to it and they just don't provide the records, or they want to try to charge you an illegal amount for the records. Now, a legal amount can vary depending on states and also depending on the method in which you requested your records. So some people use the full protections under HIPAA, meaning some claimants and patients, the full protections under certain aspects of HIPAA that provide for access and affordable access. Generally speaking, if you request your records under those provisions and ask that they be sent to you electronically to the email of your choice or the fax of your choice. The email could be where the records are sent in PDF or by a download link. But in any event, all of those methods are digital or electronic. They are not paper, copy, ink, print, mail, and charging $1 a page as such, or whatever the crazy amount may be. And of course, there's more labor time that would cost that office. Often the offices don't do it themselves. They have a third-party vendor whose business it is to do this. And of course, they want to get paid. So if you have requested the records and you have reason to believe that you are being overcharged, and this would happen if you use the high-tech HIPAA access rules under HIPAA, and they're trying to charge you something more than, say, $6 to $10, it might be that they're violating. So, and also they have a 30-day generally time limit. I know that's trying to get changed. Some people are trying to actually shorten it. I don't know if that's a good idea, but nonetheless, if they don't meet the deadline and you're running out of time, or they try to overcharge you and they make your records illegally charged, whether or not you come up with the money to get it, I would argue that that's a violation. Anyway, sometimes they make it so much that a lot of people just walk away from the records and then they can't pursue whatever is in their life that they needed those records for. Okay. It doesn't have to be Social Security. It could be a plethora of other things. The rule is if you want them as a patient, you get them. And if you want them in an electronic format that doesn't cost diddly for the provider, you get them at a very, very, very low cost if they're going to choose to charge you at all. So if all of that gets violated, and that'll take a little due diligence on your part to find out, but I've given you a few hints right here. The avenue, if there is a HIPAA violation, and you have to, again, check out those rules, you can file a complaint with the Office of Civil Rights. That's federal. And they enforce HIPAA across the board. Now, they're not going to be your lawyers and step up for you in particular, generally speaking, which is unfortunate. That means people are still hanging out to dry. But once in a very blue moon, the OCR will sanction a medical provider. I presume that's because they've gotten more than one complaint. Or maybe it is one big bad complaint. I don't know. Remember, they would go after them if they violated privacy rights as well. Here, we're not talking about that. We're talking about your right to access under those privacy rules, you as the patient. So I just want everyone to be aware that you do have the recourse. It's very, very quick and easy. It's like a 2-page form that you can literally fill out and email right to OCR. They give an email address for that as well as a fax, and I'm sure you can mail it if you prefer. But that's how super quick it can be. It can literally be 5 minutes of your time. File the complaint. Make sure you, add the proof of what you're saying if you have it. And that might be a way to, get some of the more abusive providers, of which there are far too many. Just had one today, trying to extort some funds out of a patient, and it's kind of sickening. But until, you start forwarding those issues onto the OCR, I don't see it improving. So I urge everyone to consider doing it. If you are being abused and contacting the office or sending a second reminder to them of their obligation to send it to you is ignored. Or they might respond to you and say, you have to send us this much money, or they might say, no, you have to get a lawyer and have a lawyer send it. All of that is false. And I would think even urging you to do that would be violative in and of itself, aside from the fact that they haven't sent you the records. So just something to look out for. Office of Civil Rights complaints. It's super, super simple to do. I have a copy of the form on my computer for those who need it. But anyway, take that under your hat. I don't yet know of a niche boutique law practice that does federal, has a means or a method of putting into their business model, being able to represent patients who are under the abuses of medical providers in this way, or the vendors. But the vendors, the medical provider is responsible for the behaviors of the vendor. So anyway, until that comes to be where a boutique practice starts to get involved in there, can make it into a viable part of a practice that can at least break even. There's got to be some way. The only resolution I'm seeing is OCR or state medical boards potentially. Other than that, right now, I can't really think of anything else except maybe filing a small claims suit, but I don't know if that would work or not. We'd have to do a little delving there, but the easy one is OCR. It's not going to probably resolve your issue, but it might start building a file against some of these abusive providers. Okay. All righty. Thank you so much, and hope it helps you. Bye.